Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. If you joined us last week, we talked about leaves of absence. And today, I want to do a similar discussion about reasonable accommodations. Leaves of absence and reasonable accommodations often go hand in hand. Remember, somebody can be working but need some time off, like a partial time off. So they're getting a leave of absence, but they're still working. And then maybe while they're working, they need an accommodation. They need more frequent breaks or they need a piece of equipment. So oftentimes leaves of absence and reasonable accommodations are related, but they need to be looked at separately. It's very important that you consider leaves of absence separate from reasonable accommodations. Now, when we talk about reasonable accommodations, we have the same framework as we do for leaves of absence. We want to start with law and policy. The law here is interesting because I think a lot of folks tend to think about leaves of absence as being medically related. But remember, we also have religious accommodations, and that became a big deal during COVID, particularly with respect to wearing masks and getting the COVID vaccinations. So remember, it's not just medical issues, it's also religious beliefs and practices. So when you look at the law, we had a big change in the law at the end of last year regarding reasonable accommodations. And it really became an important issue in terms of the undue hardship. It used to be that the standard for religious accommodations was lower than medical accommodations. For a religious accommodation, you could show that there was minimal undue hardship to the employer, and that was enough to reject a religious accommodation request. No more. The U.S. Supreme Court made clear in a case involving the United States Postal Service, in fact, that the burden on the employer is to show substantial hardship. So it's very important to understand that if you're going to try to deny an accommodation, whether it's medical or religious in nature, you're going to need to evaluate it case by case. And you're not going to be able to just say there's an undue hardship. You're going to have to show there is a substantial undue hardship. So how does it negatively affect your operations to provide the accommodation? What kinds of issues can arise in the workplace because of the accommodation? That is a critical part of this analysis, and you've got to be prepared to do that. So when you're looking at your policy, and this is the same with leaves of absence, you're going to need forms, right? So we use, for example, a reasonable accommodation questionnaire where we're helping the employee and their healthcare provider provide the information that we need to be able to make a decision about whether they are entitled to an accommodation. So your whole administration process really needs to be, of course, compliant with the law, but also easy to understand, easy to jump in the middle of, like really as simple as you possibly can make it. You don't get points for overcomplicating reasonable accommodations or, for that matter, leaves of absence. It's always going to be better to keep it straightforward and simple. Okay, now, one of the things we looked at, of course, with leaves of absence was multi-state issues. You have to look at the same thing under reasonable accommodations. Federal law, the Americans with Disabilities Act, and Title VII, those two laws are going to address accommodations under federal law. In California, we have the Fair Employment and Housing Act, the FEHA, which is going to apply. So if you do have some employees who are out of state, you're going to want to make sure that you look at the standards under federal law. Of course, as we talked about last week, you also have the ability to apply California law, for example, if that's what you want to do. So you can always apply a higher standard. Remember, you can't apply a lower standard. Now, when we talk about accommodations, just like with leaves of absence, you need to have a team who is handling these accommodation requests. It could be the same team that is handling the leave of absence request. It could be one person doing both and other things. But you've got to have a designated person. To me, it's like what happens when there's an accident and everybody thinks somebody else called the authorities, but nobody actually did so. That's a problem. It's the first thing you learn in first aid, right? I've talked about this before. You come on an accident scene and they tell you that, the first thing you do is, has anyone called the police? Has anyone called the fire department? Okay, I'm going to do that now. You go get blankets from my car for the person who's injured. You help them push the car off the side of the road, right? Someone has to take control. You need a quarterback, okay? And it's the same thing when you're dealing with leaves of absence or reasonable accommodations. You need that quarterback. You need someone who is actually going to push the process along. There may be more than one person on the team. That is great. That is fabulous. But you need somebody who is responsible and somebody who's going to be able to be leading the process and understand how the process works. Okay? Now, you also have to think about third-party administrators. We have some clients in the firm that use a third-party administrator for the reasonable accommodation process. And it's very difficult because obviously the employer still has to have the interactive process conversations with the employee. You really can't have a third party do that. They just are not going to have the knowledge about what's going on in the workplace. So it's one of those things where you can have a third-party administrator, but then you've got to figure out what they're actually going to be doing and how are they going to be useful to the process. I personally think they are far less useful in the reasonable accommodation process than they are in the leave process, because the reasonable accommodation process requires that interactive dialogue, that back and forth. It's hard to do that with a stranger who the employee doesn't really know. Not impossible. If you want to do it, you can certainly make it work. You give scripts. You make sure somebody from Human Resources is listening in pretty frequently to make sure they're doing what they need to be doing. So it's not that you can't do it, but you're just going to have to manage it a little more closely. Documentation. All right. Just like leaves of absence, documentation is critical here. And it's documentation of what the employee asked for, what you considered, what the result was. Did you give the accommodation? Did you not give the accommodation? Did you partially give the accommodation? How did that work? And whatever medical or other documentation you got as part of the process, where are you going to keep it? How are you going to manage it? All of those issues are very important when it comes to reasonable accommodation, particularly because the main reason that an accommodation will be denied is because the employer says it imposes an undue hardship, a substantial burden to the employer. Well, it's very hard to show that if you don't have documentation, if you don't have the ability to really think about and write down, why am I doing what I'm doing? And it can't be just because the manager or the leader told me it's going to impose an undue hardship. That's not going to be enough to justify that decision. So we really want to make sure that we've got the documentation in place and that we understand and explain why we're doing what we're doing. Now, you've obviously got to stay up on the rules, just like you do with leaves of absence. So you want to make sure that you know when the rules are changing, whether it's actually a law that's changing or it's guidance from the Federal Equal Employment Opportunity Commission or the Civil Rights Department here in California, any other state agency or governmental agency where you may be doing business. So you do have to stay up to date. Again, find law firms you like that do podcasts, that write blog posts, that do webinars. There are lots of different firms that do that. We do, of course, but there are others. And it's good to have a lot of different perspectives in this area to make sure that you really feel like you're understanding what's going on and you're dotting your I's and crossing your T's. Now, one of the things we have to talk about in the reasonable accommodation arena that is different than leaves of absence is the interactive process. remember, what's happening with a reasonable accommodation is the employer, the applicant, is asking for the employer to do something. And there needs to be a two-way communication between the employer and the applicant or employee. We cannot say, for example, these are the 4 accommodations we're willing to give you. Pick which one you want. And if you don't like any of these, you're out of luck. Not going to work that way, right? So part of what you want to understand about the interactive process is most of it should be verbal. Most of it should be a meeting, a phone call, a Teams, a Zoom, something where you're actually having a dialogue back and forth. You can summarize those meetings and that dialogue in writing, but it's very tough to have an interactive process in writing. You need to make sure that the employee understands the level that they can ask questions and the pushback that they have in terms of potentially rejecting an accommodation that you suggest as not being effective, for example, and needing to actually take a look at other things. So I really want you to think about this idea of how are you going to interact with your employees, your applicants? What culture are you going to bring to the table? Because this is often a time when an employee or applicant is stressed. They're asking for something that they don't know if they're going to get, but they think they need. And they're not sure what documentation you're going to require them to provide. They're not sure how the process works. So they may come to the table feeling a little uncomfortable. And you've got to figure out how to get the information you need and make them feel more comfortable. So it's really worth thinking through in your organization. For example, if you're a fully remote workplace, you're going to have a remote conversation about the interactive process and an accommodation request. So that just may not be something that you thought you'd be doing, right? You figured, well, we're a remote workplace. Maybe we'll just do everything in writing. No, you're going to want to make sure that most of these communications, to the extent possible, are going to be in person, live. That doesn't necessarily mean a body is standing before you, but live in that there's some back and forth possible. Now, the other thing about leaves of absence is each of these leaves may be dealt with differently under the law. So for example, in California, we have hundreds of reasons why someone could be off work, right? They could be in the military. They could be a Civil Air Patrol member. They could be going to their daughter's school program. They could be needing time off for jury duty or witness duty or bereavement or reproductive loss. There's just so many reasons why somebody can be off work. In the reasonable accommodation arena, it's not as formulated. It's not as dictated, like this is how much time you get and this is how it works. It truly is a case-by-case basis. So you may go from a situation where somebody had what we call a statutory leave of absence, a leave of absence where the law dictates how much time they get. And then when that's over, the question becomes, okay, well, are they entitled to more leave as a reasonable accommodation? And what documentation do I need to help me get to the place where I can make that assessment fairly? And remember, you're going to treat these employees like they're your favorite employees in the world, right? You're going to make sure that you are being fair and just to every applicant, to every employee. And you're going to look at the situations case by case to make sure that you really have a good sense of what they need and what they're asking you to do. Now, if you need help in this area, we do have our 2-part workshop coming up on leaves of absence and reasonable accommodations. It's September 19th and September 26th. I'm working on the materials now. As you know, if you've participated before, these are highly engaging. They are via webinar, but they're live webinar We put you into groups. We work out all sorts of hypotheticals. We change the hypotheticals every year. So the program is brand new every year. And we have folks who come every year. This is the advanced session. That doesn't mean you have to be advanced. It just means that we're talking about more advanced issues. We have a beginning session in the spring where we talk about more of the basics. I have folks who come to both of them every year because they want the refreshers on the basics and they want to see what kinds of situations other employers have had to deal with in the fundamental session. So if you want to register for those, you can go to our website. Space is limited because we want them to be interactive. We want to make sure everybody has a chance to participate. So you should get signed up for those right away. And I think you'll love them. They're really fun. I'll be the facilitator in both of those sessions. So I guess that's good news or bad news, depending on if you want to be with me for 2 days. But I would love to see you there. Thank you so much for joining me here today, everyone. It's such an honor and privilege that you take time to listen. Remember, I'm always open to feedback. Any ideas you have, any suggestions you have, I would welcome them with open arms. So feel free to email me anytime, reach out, and let me know what your thoughts are. Thanks again, everyone. Have a fabulous day. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.